Good morning, friends. My today topic is bail is the rule and jail is the exception. Honorable Supreme Court on Monday, that is 25th November 2024, granted bail to a man accused of counterfeiting currency who had been incarcerated for 2 years and 6 months, invoking the principle that bail is the rule and jail is the exception. Appellant has undergone incarceration for a period of 2.5 years. The counter filed by the state shows that there are no antecedent reported. Therefore, in the facts of the case, appellant deserves to be enlarged on bail, following the well-settled rule that bail is the rule and jail is the exception. Honorable Court said. A bench of Justice Ave S. Oka and Augustine George Massey emphasized that High Court should not impose time-bound schedules for the conclusion of trial when rejecting bail applications. In this the court said, before we part with this order, we have noticed in several orders passed by different high courts that while rejecting applications for bail in the routine manner, the high courts are fixing time-bound schedule for the conclusion of trial. Such directions affect the functioning of the trial courts, as in many trial courts, there are very old cases pending for disposal. After rejecting the prayer for bail, the courts cannot provide some kind of a satisfaction to the accused by fixing time-bound schedule for the trial. The Honorable Court observed, referring to the constitutional bench judgment in High Court Bar Association, that is Allahabad versus State of UP, Honorable Court reiterated that constitutional courts should refrain from directing lower courts to dispose of cases within specific timeframes except in extraordinary circumstances. The accused had been arrested in connection with a case registered at Islampur Police Station under sections 489A, B, and C, read with section 34 of the IPC. The case involved 6 counterfeit currency notes of rupee 500 denomination, which were detected by the ICICI Bank official in May 2024 during cash proceeding. The investigation allegedly traced the notes to the accused. Bombay High Court, while rejecting the accused first bail application in February 2023, and Honorable Supreme Court declined to interfere with that decision in April 2023. High Court again denied bail in January 2024 order, directing the trial court to conclude proceedings within a reasonable period. By that time, the trial had not progressed beyond the framing of charges. The accused subsequently moved the Supreme Court seeking bail. Honorable Supreme Court has flagged the trend of imposing deadlines for case disposal many times in the past. Honorable Supreme Court on October 4 said that the trend of high courts directing trial courts to conclude trial within a set time frame instead of granting bail without considering the trial court's case backlogs is impermissible. Impermissible. The same day, the court refused to request for a timeline for disposing of an execution matter in the Bombay High Court, noting the heavy workload of judges in the Bombay High Court. The same bench in July this year set aside a Patna High Court order directing the trial court in a criminal case to complete trial within a year. noting that the High Court did not consider the huge pendency of cases in trial courts. In August, the bench cited the Constitutional Bench judgment orally expressed that it cannot entertain petitions seeking fast-tracking of hearing in High Court. For more details, you can go through the case, that is SANGRAM SADASHIV SURYAVANSHI versus State of Maharashtra. Case title is Criminal Appeal Number 4758 of 2024. That's all. God bless you all.